Hello there, welcome to BloombergQuint. And this evening, we're doing a deep dive analysis of the new guidelines for social media platforms and streaming services. Earlier today, I spoke with Khaitan's Supratim Chakraborty on the specific compliance challenges the new rules will throw up. Before that, I spoke with Dhruva Advisors Ajay Roti on several unintended consequences when you view these guidelines from the tax lens. You'll find both these conversations on our timeline in case you missed it. For this third conversation, I have with me Raman Chima, who will break down the concerns around encryption that these rules have led to, both for users and messaging platforms. Raman, welcome to the Fineprint. Your first broad, reaction of, when you saw the specific requirement for significant social media intermediaries when it comes to identifying originator originator of malicious information, if I can broadly call it that. And before you answer that, a while back, the ministry just put out the threshold for platforms that will qualify as significant social media intermediary, and that threshold is 50 lakh registered users in India. Raman, your first thought on finding this encryption landscape in the intermediary guidelines?
Firstly, thank you for having me. And it's my pleasure to try and explain it, although the rules are confusing, and part of the problem with them is that they seem to imply one thing, and then you check the legal authority and it ends up meaning something else. And you're absolutely correct that it has provisions there which say that significant social media intermediaries, that means entities above a certain threshold, have additional obligations upon them. They have to be notified by the government, which we have to see. The government may give them the numbers, but you have to see the actual notifications they issue. And then the rules propose additionally on top of that, that even so significant social media intermediary is engaging in messaging communications, that they have further obligations that may flow on them. And the rules try to imply that if an order is made to them by government or courts under appropriate legal process, and here it seems to define it as Section 69 of the Information Technology Act dealing with interception of communication, that they may be required to identify the originator of the message. And this is a concern that's been made very clear to the government of India over the last 2 years. It fundamentally raises issues about encryption and how end-to-end encrypted communication works. Because in end-to-end encrypted communication, it is very difficult for most providers who run those services to be able to actually ensure and guarantee their end-to-end encryption if they be forced to identify the originator of a particular message, because that's a very important thing for you to understand, right? In end-to-end encrypted communication, in effect, a provider may know that X person has messaged Y person, and perhaps a Y person has messaged in turn another person Z. But what is inside that communication, they can't see because it's end-to-end encrypted. They literally cannot look into that stream if it's actually end-to-end encrypted. And examples of that are the Signal protocol, Signal Messenger app, WhatsApp, and others. Some companies do keep metadata about who messaged whom, and some of them do cooperate with government requests. For example, WhatsApp does cooperate with Indian government requests on identifying who perhaps logged into a service at a point of time and sent perhaps communication. They don't know what's within that. But the government-specific mandate on saying originator of content makes it completely impossible to be able to actually guarantee end-to-end encryption. And this is exactly a concern that's been actually even brought in court in India, because there is an ongoing lawsuit, a case that was in the Madras High Court that has now partly come to the Supreme Court, where a government-affiliated academic, somebody associated with IIT Madras, said that you could actually identify the originator of content despite communications being encrypted. And actually, most experts in the space, including other encryption professors at the IITs, filed counter evidence saying that actually that's not the case. If you try and timestamp somebody as being the originator of a particular message, you are in effect breaking encryption. You're providing a vulnerability that others can also misuse and go into.
So, Raman, if I understand it correctly, the likes of Telegram, Signal, WhatsApp, they're based on this promise of encryption, right? And privacy is a very integral part of all of this. Now, through this intermediary guidelines, the government is trying to find out that first originator of information. They've also said that if this first originator is located abroad, then the individual who has disseminated that information first in India, that individual will be identified as the first originator. Help me understand that. Is this encryption built into all models, all popular messaging platforms? And somebody told me that you think of it as an envelope, right? That says that, look, let's say Payaswini has written a letter to Raman. The messaging platform will not know that, the contents of that letter, but they'll surely know that who is it from and who is it meant for, right? So do all platforms know this? And is this information very readily available at a click of a button to them, for them to be able to then, share these requests basis a court order or a competent authority's direction?
A short answer is no. Not all providers keep this information. Some of them, in fact, explicitly make it clear that that's either not within their business model or their design of their product, because they believe, for several reasons, that it might be potentially a risk. It could be misused. It could be used to target people, that they don't keep it. And some do. And remember, this is pretty broad. This is not just, for example, the major popular encrypted messaging services you may regularly use. A lot of everyday communications between businesses also now goes via encrypted channels. And in fact, in the space of cybersecurity and global communications, the push is to try and encrypt at least the communication streams as far as possible. Because remember, when you encrypt a communication stream, that also means a hacker, somebody who's trying to snoop onto my transmission, perhaps snoop my Wi-Fi, or who's trying to somehow run man-in-the-middle attacks to get the communication stream. They can't break into what you're accessing. And some providers, as I mentioned, do keep data about who perhaps has an account on their service, who messages whom at what points of time. In fact, if you may remember, that's one of the main allegations and concerns against WhatsApp after its acquisition by Facebook, that they are keeping that data, the subject of a lawsuit in India and of data protection investigations globally. And most people say that not all providers want to keep that, and it can be quite risky. So the short answer is that the practice varies. And these rules do try to force one system on all providers and not just on encryption. For example, they say that social media intermediaries and significant intermediaries should even keep all data pertaining to users for a certain period of time. It's a legal mechanism called data retention that in many countries actually has been declared to be illegal. In the European Union, there was an EU law that made data retention mandatory, that was struck down by their highest court. We've seen similar provisions be struck down or limited in other regions, including in the Asia-Pacific region. And that's something that these rules also put in place there. Now, what the government has tried to do or claim is they put in some protection and saying, if they're less intrusive means you don't have to do this. But the bigger, more confusing background to all of this is that this is actually beyond the government's powers to regulate in these measures. Because what the government is going into here are significant new legal powers or new legal mandates, for which they actually need to either amend the Information Technology Act or they need to create new law that Parliament passes, which they have not done. Instead, here they've taken a very limited topic, namely the due diligence that intermediaries are normally supposed to perform, and they've expanded it massively to create new obligations and duties. And so while the language is concerning, the other lawyer part of me would come back and say, well, at the very least, that's unlawful. But also an intermediary could turn back and say, well, at max, what we'll do is you might try and say we're accountable for the content of or the communications of what our users are transacting on our service, but you can't force us to do this. So it's actually a very uncertain, weird legal structure that the government has chosen to create.
All right, of course, and I'm sure you and other civil society sort of activists will, probably seek court intervention at some point on this. Let me come. I have one last question on consequences for platforms, and you partly touched upon it, which is that presently the business models of some of these platforms already allow or already have this information versus some they don't, and these are some of the global sort of names that we're talking about. Will they have to, if these rules in the present shape and form continue on the books of the statute, will they have to specifically tweak their models to India?
So I think the challenge is that they're in a difficult situation because they will be caught in a catch-22. they would like to perhaps tweak their operations or know that the government is definitely intending to try and force them to do that. And that if they don't do it, what the government will try and say is, if X police agency in Maharashtra or a civil lawsuit is filed in another part of the country, the government will come and say, well, this intermediary is not following our rules. They can be held directly legally responsible for whatever happens there. We won't help them. We won't apply the qualified immunity that Parliament intended to give to internet platforms to X service because they're not playing by our rule book. And that's concerning. So it's actually going to open up a huge explosion of legal uncertainty. On the other hand, platforms could come back, and messaging services could come back and say, well, your rules, the only consequence of not following them is that you will say that we don't have this qualified immunity. Well, thank you very much. We will continue doing what we can. And if you try to separately penalize or issue an order against us, we will point out to you that you actually don't have the legal authority to do so. And that's a tricky situation the government's created. One more thing that I'll just note for you briefly is that in passing these rules, the government's actually significantly opened up its legal powers, because the earlier rules that it had, which were subject to a Supreme Court judgment back in March 2015, in the now famous Shreya Singhal case, those original rules are only framed under Section 79 of the IT Act, which talks about the liability of platforms and said that they're generally not supposed to be liable for what their users do, provided they follow certain requirements, including due diligence as specified by the government. Now, these new
what
rules,
we usually call as the safe harbor for intermediaries, right?
exactly, safe harbor. And what these new rules do is actually much broader, because they also claim the legal authority. In this very brief text, you see the beginning of the rules from the Section 69A blocking powers that you may have seen more actively in the news earlier this month being used to target Twitter. And what's striking to me is two things from that. One, well, there are separate rules for blocking that already exist. How is the government issuing further rules claiming authority using that provision? That seems to be legal subterfuge at best and, well, unconstitutional action at worst from the government. But secondly, perhaps they're also trying to claim that authority because they will try, even though it's not in the rules, to say, well, you're not following the rules we've written here, we will penalize you. We will bring an action against you. So we have to wait and watch. But remember, I do think that tech platforms, whether in India or abroad, have the option of pushing back and saying, well, these are just best practices you would like us to follow. We will choose not to follow it and see what comes to us in court. But we'll have to wait and watch. And I would suspect that the government will use the full weight of their authority and political influence, even if it's not fully legal, to try and force people to follow these rules.
Okay, we've talked about the consequences for messaging platforms. I quickly want to shift the focus to users. Raman, let's say you identify or the platforms do give up this information and hand it over to the government that, look, this malicious message that you've come to us with asking for the first originator, this person XYZ from Patna is the originator of this information. Now the government will sit in judgment of that, whether that information qualifies as an offense, and then there will be liability, or will the intermediary need to do anything more, or then after giving up that information, it's between the government and that XYZ person in Patna?
So, well, technically, it should be between the government and the person who they may be choosing to investigate. Technically. Now, the problem, as you know, here is that surveillance and the threat of legal action itself is caused to intimidate people. And that is what has been happening over the last month and the last 2 months as well. If you notice some of the cases that have been brought by the government targeting protesters or people who disagree with it. And also, the other thing you must remember in India, of course, is that it's not the final legal judgment, it's the process itself that is punishment. So people should be worried about that. But the bigger worry that I think all Indian citizens and residents should have is that in order to facilitate these government requests, providers being forced to bake in vulnerabilities or not roll out encryption, because the government is saying, well, if you roll out full encryption, you won't be able to tell us who the original originator is. And that is actually an attempt to reduce the security and reduce the tools of privacy made available to users. And that's what we should be worried about. So not necessarily the immediate legal consequence, but this is actually a sort of regulatory push. You could argue a slightly bullying effort by the government to say, well, don't deploy fully secure, fully private tools in India to users here. Make it easier for us to surveil people. And by the way, as you know, we use that surveillance to sometimes tell people to stay in line.
All right. Raman, last question then. If I stretch this intent that you spelled out very beautifully that the government is trying to do, and let's say there are political colors to this, rule making, to what extent that action can be stretched? Can the government only go with a specific message to these platforms, or we can also see them drawing up a list of words which they find that will be sort of a witch hunt, if I can call it that, and trying and to catch sort of people whose ideologies or opinions they may not like, and then force these platforms to give up this huge data set of users who may have sent messages around those words or ideologies.
If you asked me as a lawyer a decade ago, the Indian government would be basically asking people to be identified or disclosed based on messages or concepts they were discussing, tag words. I would have said that seems Orwellian. Whereas, unfortunately, the reality today is that's exactly what's happening in a different form. You've already seen the government saying literally block the discussion of entire hashtags. And you may later say the hashtags are problematic. You could even say somebody is using a hashtag in a way that's criminal in terms of the speech they may be using alongside that hashtag, but they are literally pre-censoring the discussion of entire topics saying, we don't like that. And unfortunately, based on experiences I've seen in the technology industry, as well as from civil society monitoring what government agencies in India do, you cannot think that is beyond the realm of doubt. In fact, it is right now within the realm of practice that they sometimes want people to disclose individuals who use certain tags or discuss certain ideas at the very broader way. They say, for example, report anyone who might have used X hashtag, identify their IP addresses, who they are. And these rules may make it harder for platforms to push back. And I think that's the real intent, in a sense, behind these rules. And that's very concerning to me as an Indian citizen, is that it seems to be an attempt to tell platforms, do not push back. Do not do what Twitter did, which is to say, we will temporarily comply and then push back on what you did. We will challenge what you're doing. That seems to be the intent of these rules here. And remember, this is happening in the backdrop where the government is refusing to improve India's surveillance practices. Its own advisory committee on data protection, chaired by Justice Sri Krishna, told them now several years ago that your surveillance practices in India, your laws on that as well, are in fact not even compliant with the Supreme Court's ruling on the right to privacy being a fundamental right. They have said that judges should be involved in authorizing surveillance. This is what MPs have also brought in Parliament and raised. And even Indian judges, Justice Sikri, in the second Puttaswamy case, the judgment on Aadhaar, said that preferably judges should be involved in surveillance and don't treat every single person as being a potential criminal suspect. These rules today don't change the requirements for surveillance, and they make every single user of an online platform a suspect. And they ask technology companies to keep data about them in order to hand it over to government agencies if government agencies seek it.
Sure. Thanks, Raman, for very clearly and sort of candidly laying out for us the potential misuse of this particular rule in the intermediary guidelines. And as these guidelines are implemented, we'll see how these requests to these platforms unfold, and whether or not there is a court challenge or whether or not this actually ends up in court as an unlawful or an unconstitutional rulemaking. Thank you, Raman, for joining us here on BloombergQuint, and thank you so much for watching.
Thank you for having me.